Hey everyone, it's Fernando here, and today I'm going to tell you whether or not you can conduct retrenchment consultations over digital platforms. Is it legal? Is it fair? And I'm going to do this with reference to the Labour Relations Act and case law, so don't go anywhere. In a fairly recent case, and I've included the case in the description below if you want to check it out later, the Labour Court had to make a decision as to whether video conferencing was an appropriate means to consult in a retrenchment process during the COVID-19 lockdown period. In early January 2020, the company commenced on a restructuring process. Due to the large number of potentially affected employees, Section 189(a) of the Labour Relations Act applied. As you would have already guessed by now, physical face-to-face consultations were not possible due to the lockdown. Therefore, there were two options open to the consulting parties. First, conduct the consultations by video conferencing, or second, postpone the process. The CCMA facilitator proposed that video conferencing via Zoom be used. The trade union then refused to participate in the consultation process, and the company elected to complete the consultations by video conferencing. The company structure changed and the process ran its natural course. Termination of employment notices were issued to the affected employees. Being unhappy, the trade union naturally brought an urgent application to the Labour Court to compel the company to comply with a fair procedure in the consultation process and try to interdict the company from proceeding with the consultation process without the physical attendance of the trade union in the facilitated process. The trade union complained that the Zoom application was unreliable and it couldn't replace physical consultation. Here is the irony, and this is completely going to blow your mind. Drum roll, please. So the trade union agreed to have the urgent application heard by the means of the Zoom application, the very video conferencing application that they so strongly opposed during the consultation process. The court found that the union's insistence on physical consultations only served their own interests and was ignorant of the bigger issue of health and safety. Under conditions of the new normal, video conferencing was an appropriate form in which meetings could take place. In these circumstances, video conferencing was a necessary tool to ensure that restrictions like social distancing, as a measure to avoid the spread of the virus, was observed. Consultation by video conferencing accorded with the new normal and was actually fair. Consultations provide all parties with an opportunity to truly engage on topics or reasons for certain ideas and the establishment of a discussion around those principles. Meaningful consultation, and I'm really talking about meaningful, entails early stage consultation, providing accurate information to all parties involved and allowing all parties sufficient time to respond and genuinely considering the responses made by all parties. And all of this can be done irrelevant of what medium is used to conduct the consultations. So, was the consultation process incomplete? Was it unfair? Was it illegal? Of course not. The Labour Court found that the trade union had unreasonably refused to participate in the process because of the use of the Zoom app. It would not be fair to punish the company because the trade union chose to abandon the process. The trade union's application was therefore dismissed. The COVID-19 pandemic has accelerated the fourth industrial revolution in South Africa. If you aren't thinking artificial intelligence or the fourth industrial revolution, you're already behind the game. Until next time, that's all I have for you today. Stay safe and ciao for now.